Testing. Is that all right?
Yes.
In compliance with the Open Public Meetings Act of 1975, adequate notice of this meeting has been provided. If any member has reason to believe this meeting is being held in violation of this act, they should state so at this time. Seeing none, we'll have the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mrs. Hutchinson,
Here.
Mr. Murray,
Here.
Mrs. Werner,
Here.
Ms. Hessel.
Here.
Thank you. Mr. Ledwin,
Here.
Mrs. Notch,
Here.
Mr. Walsh,
Here.
Mrs. McDade,
Here.
Mr. Venuto.
Here.
Thank you.
Okay, we need a motion to approve the minutes of September 22nd, 2022. Could someone make that motion?
Make a motion.
Motion by Ms. Hessel, seconded by Mr. Ledwin. Mrs. Werner,
Yes.
Ms. Hessel.
Yes.
Mr. Ledwin, Mrs. Notch.
Yes.
Mr. Walsh,
Abstain?
Mr. Murray,
Yes.
Mrs. Hutchinson.
Yes.
Thank you.
We have a resolution from 10/27. No, that's today's date. It's the Yacht Harbor Marine LLC, 1505 Yacht Avenue. Can we have a motion to approve that?
I'll make that motion.
Do we
I'll
have a
second.
second? Oh, thank you, Mr. Murray. Motion by Mrs. Werner, seconded by Mr. Murray. Mr. Walsh,
Abstain?
Mrs. Notch,
Yes.
Mr. Ledwin,
Abstain.
Ms. Hessel,
Yes.
Mrs. Werner,
Yes.
Mr. Murray,
Yes.
Mrs. Hutchinson.
Yes.
Thank you.
Okay, we're going to have a little delay right now because one of the applicants' testimony people are not here yet. He's calling them. Anything you want to say? Okay. Yeah.
Thank you.
Can I just have another 2 minutes to consult with my client very quickly? I'm sorry for the delay.
I didn't realize you're like fortune cookies. Yeah, we'll sing. Fire up those engines. Be resilient. Let's hear your battle cry. Jeez. Cough drops.
That was a big thing. Yeah. A big everything.
So I can announce to the zoning board that the next meeting is November 17th, 2022. It's the third Thursday because of Thanksgiving. We'll have to get a cake. Please turn on your microphone. Mr. Chicanis, could you please turn on your microphone, press the button? Thank you very much.
How about now? Good? Yes. Thank you. Moving ahead?
Yeah. You ready?
Okay, great. So the first thing I wanted to point out, I was just on the phone with our proposed historic architect, Mr. Barton Ross. He's actually running a little bit late, but there was some question as to whether or not Mr. Ross would be able to testify here tonight. So perhaps while he's on his way, we can address that right out of the gate. And if need
Could I get your name? I'm sorry.
Oh, I'm sorry. I should have introduced myself. My name is Peter Chicanius. I am an attorney at the law firm of Highland Levin Shapiro, and I'm the attorney on behalf of the applicant, Locale Stockton, LLC.
What I'd like to do, though, first is just kind of set forth to characterize this
Sure.
meeting. It's a little different than, we've done a few of these, but it's a little different. It's not just a regular application. So I just want to go through and explain that this is an appeal from a determination of the HPC. Now, the attorneys may describe to you, hopefully they will, some of the procedural history that led up to this point. It's only marginally relevant in the sense that you're reviewing a determination by the HPC. You all have the transcript from the January 6, 2020 hearing. Is that right?
Yes. Pre-COVID times.
Okay. That's right, you went to court between. And so you've all read that transcript, so that's the record as supplemented by any other exhibits submitted during that hearing. And you're hearing it as an appeal, okay? So we have a specific ordinance to guide your judgment when hearing an appeal from the HPC. And because it's my expectation that this may be subject to court review, I do want to take the time and read to you what we have as our appeal of determination of HPC to the Zoning Board of Adjustment. This is a document that was circulated a couple months ago among the attorney for the city, the attorney for the HPC, and myself, so that we can come to at least a common understanding of the legal representatives of the city on what the standard would be when this comes before you. So I'm going to read that to you in its entirety. I may not read the examples, but I do know this was in your packet, and I see at least one person has some highlights on it, so perhaps you've all read it. But for completeness of the record, I just want to set forth the applicable standard, and then you're going to apply that standard to the stuff that's going to happen tonight, okay? So I'm going to read it into the record. Appeal of determination of HPC to the Zoning Board of Adjustment. First, the standard to be applied. And this is actually a quote from our ordinance, section 525-37E5, which I can tell you was written, I don't want to say by me, but I was involved in its writing after several meetings among a group appointed of the Zoning Board, Planning Board, City Council, and HPC after many meetings to try to make clear in our ordinance how it would work when you appeal from an HPC decision, when an applicant appeals from HPC decision, and what the standard would be. So this, here it is. A certificate of appropriateness issued by the commission shall be required for a permit, before a permit is issued, or before work can commence, for any of the following activities within a historic district. Appeals from determinations of the construction official pursuant to referral to the HPC may be made by the applicant to the Zoning Board of Adjustment according to 40:50, this says 5D, but it's 55D-70A. Nothing herein shall be deemed to limit the right of judicial review of the action after an appeal is concluded by the Zoning Board of Adjustment. The applicant shall pay all costs for copies of any transcripts, which shall be a certified court reporter. The appeal shall be heard on the record made before the Historic Preservation Commission. A determination by the Historic Preservation Commission on issues within its authority shall be entitled to due deference. If, in the case of an appeal made pursuant to this subsection, the Zoning Board of Adjustment determines there is an error in any order, requirement, decision, or refusal made by the construction official pursuant to a certificate or denial of a certificate submitted by the HPC in accordance with 55D-111, the Zoning Board of Adjustment shall, in writing, include the reasons for its determination in the findings of its decision thereon. The determination of the Historic Preservation Commission may be overturned only if the Zoning Board of Adjustment finds that the Historic Preservation Commission determination was arbitrary, capricious, unreasonable, or contrary to law. We then, yes,
No, it's my understanding, since we are an appeal, no testimony will be permitted. Is that correct?
we're going to get to that.
Thank you.
I'm going to read the standards and then we'll do that. Explanatory statement. Pursuant to Section 525-37, the explanatory statement was an attempt to help you, help guide your decision-making on what is arbitrary, capricious, unreasonable, or contrary to law. The explanatory statement, pursuant to Section 525-37E5 of the City Code, determinations by the HPC on issues within its authority are entitled to, quote, due deference, close quote, and may be overturned only if the zoning board finds that the HPC determination was arbitrary, capricious, unreasonable, or contrary to the law. This is commonly referred to as the arbitrary and capricious standard of review, which is a highly deferential standard of review under the law. This simply means that a determination will not be disturbed unless there has been a clear abuse of discretion. Review pursuant to this standard is intended to be a determination of validity of the HPC action, but not the substitution of the zoning board's judgment in its place. This means that even if the zoning board doubts the wisdom of an HPC determination, there should be no reversal in the absence of a clear abuse of discretion by the HPC. Basically, the zoning board must determine whether the HPC made a decision pursuant to the HPC Commission design standards and properly exercised its discretion under the city code. The law recognizes that government agencies like the HPC have a peculiar knowledge of local conditions and must be allowed wide latitude in the exercise of their delegated discretion. Furthermore, the HPC's recommendations should be considered with the same care afforded to all expert information before the zoning board, and damage to the historic preservation district is an appropriate consideration under the negative criteria for granting any variance from any design standard. Similar to other applications before the zoning board, the applicant has the burden of proof to demonstrate they overcome this deferential standard. There's then two examples that I'm not going to read, but hopefully you've read them in your packet, and if anybody has any questions about those, I'll answer them. So I want to highlight some of the important parts that I think are relevant to what you're going to hear tonight. First, although council will highlight their positions and issues, essentially you're being asked to review the HPC's determination regarding certain railings and stair designs and overall facade of a building. In my opinion, those are things that are within the scope of the zoning of the HPC's areas of expertise. You've heard me say at other occasions that there are things that they think are within the scope of their expertise, and I don't think they are, or that at least it's more within the zoning boards. Issues such as where driveways enter a roadway, sometimes parking, are issues that I think are better for the purview of the HPC, even though they may marginally affect the facade of a building. So when I believe that things are within our scope, I say so. In this instance, things about Chippendale railings and stairs and all of that, those are the kinds of things that I think are within the HPC's purview and within the scope of their areas of expertise. If something about that changes tonight, I'll say that, but based on my reading of the transcript, that is my impression. But you're right to exercise your own judgment in that regard. Also, with regard to the record on appeal, we passed this ordinance, and in fact, I think this sentence that I'm about to read was added in 2017 to clarify that the appeal shall be heard on the record made before the Historic Preservation Commission. The reason for that line, in my opinion, and it's not just my opinion, I was there when we wrote it, is that the HPC has certain requirements of membership and certain areas of expertise regarding historic matters. So on things that are within their scope, it's important that they hear it first so that you can hear their opinion on it and then make your judgments when it gets to you. If new things come in when it's before you that weren't before the HPC, then we haven't heard the HPC's opinion of it. We make that clear in our ordinance so that applicants know that if they want something to be considered by the higher boards, meaning us or the Superior Court, that they first have to make a complete presentation before the HPC so that the HPC can hear all different aspects and apply their expertise. So therefore, as you see me do before, in fact, we rejected testimony from our HPC chairperson a couple months ago because we limited it to the matters before on the record. So that has been our experience. Now, there may be an application tonight to expand that record, and I'm inviting you to exercise your discretion on that, but keeping in mind your ordinance, and council can explain why they believe it's appropriate, and you can make a decision on that. but our ordinance does say what it says, and it meant to say it, and it had a reason. So those are the issues that I think are most likely to come up tonight. That's the standard I think you're to apply. Does anybody have any questions? No? Okay. So we do allow,
Let me just have a question about testimony again. As the standard that you just read into the record says that the appeal should be heard on the record made before the HPC. So to me, that excludes testimony. Am I erroneous in that thought?
no, I think I
Okay.
mostly just said that. But
Okay.
there may be an instance, I can imagine an extraordinary situation where from the time the HPC hearing happens to now, something new occurs, okay? Some new law or there's a hurricane in between and it affects the building. And therefore, there's an extraordinary reason why information that wasn't available at the time the HPC hearing occurred is now available. And I think the prudent thing to do would be to send it back to the HPC if something extraordinary happens. But absent the extraordinary, you should review, it should go to the HPC, they have a full hearing, the applicant says whatever they want to say there, and then you get the record, and then you make a decision. So I generally would not, I think it would be an extraordinary thing to supplement the record, and I think there would need to be very good reasons for it. But to say never is somewhat strong. You need to hear it, and there may be some really great reason to do it that makes perfect sense to you, and then I think it would be in your discretion to do it, but also to say, well, wait a minute, that wasn't with the HPC before, so, send it back down. But we did that. We did that on this application, incidentally. An issue came up about a wall. We weren't comfortable deciding that, and they went back to the HPC about the wall. And this kind of has come back up now. So we've done that too. But that's the answer is it should be on the record below absent some extraordinary reason that you have to keep an open mind to hear. And whether or not it's, in this case, that's going to be up to you.
Okay, yeah. Now, the reason I ask, in my experience in appellate practice, it's extremely extraordinary for there ever to be testimony before any appellate body. So I just wanted to make sure that we all understood that.
Yes. I've seen it happen, though. I've seen it happen on a prerogative writ under extraordinary circumstances, but it really shouldn't. Okay?
You can tell me later when it happened, okay?
I will.
Well, on that note, I think that because our expert is on his way, again, he's running a bit late, that might be the first thing we want to address, because obviously, as Mr. King and Mr. Gillenschwartz are aware, we will be making an application to expand the record with Mr. Barton Ross's testimony, who is a historic architect that we were hoping to have sworn in as an expert, and he can give some testimony.
Well, tell us why you think they should.
Well, in this particular
Do I
case-
give your reasons and let them?
Sure, sure. So I'm not sure if the zoning board is aware of this, but one of the reasons why it's been so long since the HPC hearing, and now, among several reasons, was that this matter actually was brought up to the court to address not only HPC's decision, but a number of other items as well with respect to this building. One of the arguments put forth by the city was that the applicant had failed to exhaust administrative remedies, which means they didn't appeal the HPC's decision to the zoning board. Now, of course, our position was that that was not required. It's not actually a jurisdictional requirement. And when you can prove that such an appeal would be, the legal standard is futile, it can stay with the court. The court elected to say, okay, send it on back down and see what the zoning board has to say. Part of that involved an argument between, obviously, the applicant and the city, which really revolved around one particular item. My client was of the position that when we initially filed our appeal some time ago, additional documents that were requested of us were actually not a part of the record below made before the HPC. They were actually supplemental additional documents that technically weren't required for an HPC application, and again, were not submitted to the HPC. But the reason the city gave was that, listen, if we want the zoning board to make a good decision, we want them to have a very comprehensive review of this issue, then we want to give them whatever we feel is necessary in terms of what has happened in the past in particular. The plans, again, items that are not technically required if they're not part of the record below, but that was the intention there. My office actually took a very strict reading of your ordinance, which Mr. King has just read to you, which was understood, but the ordinance is very clear. It's based upon the record below, and it's an arbitrary and capricious standard, which incidentally is the identical standard and rule if it was to stay in court. Arbitrary, capricious, and it's based upon the record below. So we thought it wouldn't make sense to do either of those items. One, because it's in violation of the ordinance, and two, the court could do the exact same thing that we're asking the zoning board to do here tonight. The judge made the decision and said, well, send it back down to the zoning board, give them what they're asking for, allow them to have their full and comprehensive review to supplement the record with those additional items, see what they say, and to the extent you need to appeal that decision to me, we can bring it back up. So my client, following the city's lead, said, okay, if we're in a position where the record is being supplemented, then we also would like to supplement the record, because speaking very practically about situations like this, I'm an attorney, I can stand here all livelong day and reiterate what we feel the transcript shows, what we feel the transcript says, in relation to the arbitrary and capricious standard that the board is subject to. It's never the same as when you have someone who is in fact an historic architect, an expert, testifying, answering potential questions that might come up, anything that might need to be addressed. I can only address the record below. I can't address anything other than that. And practically speaking, my office felt that it wouldn't really give the board the full and comprehensive review that it claimed it wanted, and I believe it does want, in terms of really reviewing this issue, making the legally sound and just decision that can hopefully potentially avoid the need of further litigation. And again, we were essentially following the city's lead that, okay, if the record's going to be supplemented, then let's supplement it. That we actually submitted Mr. Ross's report to Ms. Keenan and Mr. King and the city attorneys about 10 days ago on October 17th, pursuant to the MOUO, which requires that anything be on the record at least 10 days before. That was not distributed to the board based on Mr. King's position, which he has reiterated here, that it's based on the record below. There is going to be no testimony from Mr. Ross or anybody else relative to this issue. It's essentially an argument. You'll present your position, the HPC will present its position, the board will make the call. So then my office actually wrote to the court requesting a conference to address that particular issue. The judge once again sent it to the zoning board and said, let the zoning board make the call. And to the extent that you feel that they made the wrong call, that'll be part of your appeal. Should you not be successful in your actual appeal, and you come back up to me and we can address it at that time, actually formally brief the issue and take it from there. The only reason we were unable to do that prior to this hearing was simply a lack of time. Any motion has to be filed at least 16 days before the return date, which is the date that the judge will hear it. We only had 10. So I wrote that letter to the judge. So based on that, again, we're following the city's lead here, that they have already supplemented the record with some additional items. We feel it would be, it should be judicially stopped from asserting that it's based on the record below, when that is no longer the case. Additional items that were not submitted to the HPC were submitted to the board as part of the packet. So again, we just think it's a matter of just simple fairness that we be permitted to supplement the record as well. And I guess that's really the bulk of the position there.
Do you have the court order?
Yeah.
Which court order?
The court order
Just
that
referenced.
referenced the items that were to be supplemental to the record.
I do believe I have a copy here. I don't have it I might not actually have it with me here. But just to make sure the record is clear, what it really said was there was a,
I want to get the order.
fair enough.
All right, can we, I'm going to mark this B1,
Sure.
Ford 1, to be my exhibit. This is the court order that is referred in the argument. I would note that the zoning board, or the planning board, which is me, was not a party to this litigation or a party to this order.
It was not appropriate at the time.
Well, that's fine, I just wasn't.
Sure.
So it wasn't that I agreed to let the record be supplemented, someone agreed for me.
Sure.
But what this actually says, in terms of what was supplemented, to my understanding, is the following items. The resolutions of the City of Cape May Planning Board approving construction of the hotel, which is something to which we could have taken notice anyway as a board of prior resolutions. The site plans and architectural plans submitted to and approved by the planning board and the HPC, along with as-built plans of what has been constructed. So those are matters in the public record and are part of the HPC record, even if not on the January date, although maybe they were, I don't know. But these are site plans and architectural records approved by the planning board and the HPC, along with the as-built plans of what has been constructed. The third item was reapplication and escrow fees totaling $481.50 are to be paid. Aside from those items that I just read from the order, what was it that was supplemented to our record that wasn't in the record below already?
Well, what it really revolved around was certain items that, again, weren't required as part of the HPC appeals submission process, particularly the checklists. A number of items that were requested were required for applications for C and D variances, site plan approval, namely the items that are presented here. Those weren't required as part of an appeal, so again, we objected. Those would really be the items. And it's a letter from Mr. Hurlis. I don't remember the exact details, but we essentially took it from that
All right,
to
let's get a
submit into the.
complete record, because I want Judge Blee to have a complete record when he gets this. So, Mr. Hurlis, can you describe what it was that supplemented, the record was supplemented, I guess?
Are we talking about the initial completeness review that was done?
Yes.
The items that were cited in that?
Yes,
This is the June 2nd memo, okay?
and specifically the items that were requested to complete the application.
So, we, as part of our Cape May Zoning Board Adjustment Land Development Application Checklist, have a general requirements for all applications. So, as part of that, I cited number 10, which is a copy of a resolution from any prior planning or zoning board applications and HPC proof that any conditions required as a result of any prior approval granted for the subject property has been fulfilled. So I cited they hadn't submitted that as part of the checklist.
Can I just make a note that the zoning board does not have a copy of that memo? We don't give the incomplete, we don't provide the incomplete memo to the boards as a matter of regular. So I could make copies if you need them.
Or B2?
B2.
So, another important point that hasn't been brought up, the application that was filed was an application for appeal from the HPC, as well as they were requesting variances. They requested hardship and substantial benefit variances on page 6 of the application form. So, I stated on page 3 of 7, the applicant has requested a waiver from all variance checklist waivers. PA recommends that the following be provided. And I cited a number 5, which is plans and elevation of the building or structures to be erected or altered, et cetera. And that's exactly the quote from our checklist. And then then in bold, my comment was, all approved site plan and architectural plans should be provided to the board for review so they may compare what was required to what is now proposed to be permitted. All documents included as part of the HPC application should also be provided for this appeal. Then under details required for preliminary site plan approval, I cited, the application has been reviewed for completeness using the requirements for site plans as outlined in section 417-5C of the City of Cape May Code. That's a quote right out of the checklist. My comment in bold says, significant design changes proposed to the site plan design and architectural design are part of site plan review and will require amended preliminary and final site plan approval. It appears that the planning board would retain jurisdiction over site plan review and any variances that are required. So that was my opinion, that it is improper for this board to grant variances from site plan approval that was granted from the planning board. That was my concern.
Were any of the items that you asked to have supplemented, anything that related to the HPC's determination on the design issues that are of concern in this appeal?
Well, that was the first comment that I read.
Go back to that one for me.
Okay, so that was the planning board resolution, that was the second comment under item number 5 on page 3 of 7, where I said all approved site plan and architectural plans should be provided to the board for review so that they may compare what was required to what is now proposed to be permitted.
Okay.
All documents included as part of the HPC application should also be provided for this appeal. So The application package that I had didn't have any of that documentation in it, so I was concerned that the board should have that.
Did the HPC not have the architectural plans of what was approved versus what you were requesting?
Not that, I mean, what it really boils down to is what was required for the HPC appeal was a number of items which didn't actually include those plans. I wasn't there at that hearing. It was January 6th of 2020, so I can't say exactly what was placed on the record. But at the same time, it wasn't required as part of the appeal application per that checklist, and therefore that's why we objected to it initially.
Okay, well, all right, I think we should hear from Mr. Gillenswartz on that, since he was in this litigation that generated this order that
Sure.
apparently supplemented. So, and I'd ask you, in addition to whatever you want to say, can you address whether the items that were, that are purportedly added, although I'm not sure they really were, I think they sound like things that were already with the HPC, but whatever was added, whether that, you know, in terms of their nature, is similar to a new expert report on HPC issues, if you could just address that.
Sure.
Can I make a comment before we leave the issue of additional testimony? Can you explain to me would additional testimony by the expert tonight affect our decision on arbitrary and capriciousness of the HPC, since the HPC has not had a chance to hear what we will be hearing tonight?
Well, it really boils down to what happened at the court above. We initially said it wouldn't make sense to send it down. That was originally our position. And the judge elected to send it back down in order, and said supplement the record so that the board has a full and comprehensive review, a full picture of what happened here. The applicant is of the opinion that in order to present that full comprehensive picture, it's not enough for me to stand here and simply comment on the transcript. A historic expert, and this is what I had mentioned earlier, whenever you're submitting an application, you have your witnesses there. They can provide testimony, answer questions, provide clarifications. So in order to give the board the comprehensive review we feel is necessary to potentially be successful here and to avoid having to go back up to the court, then and again, based on the fact that the record had already been supplemented, that was the position that we took.
But it's not up to us to comment upon your expert's testimony tonight, since we are not the HPC. And we
that's-
don't have the expertise to say whether or not that is relevant to a decision of arbitrary and capriciousness.
Well, if that's the board's decision, that's the board's decision.
Well, it's only my opinion. I'm sorry. I'm not the whole board. I think everybody obviously should have a
Yeah,
chance
it's
to
the
say.
board's prerogative to make that decision, of course.
Mr. Gillenswartz.
Madam Chair, can I be heard now? Yes. Thank you. I just wanted to address preliminarily, my name is Chris Gillenswartz. I'm the solicitor for the city of Cape May. It's kind of uncommon for the city solicitor to be here, so I'll just address that first. I could not sub in for Mr. King in his capacity as zoning board solicitor. There's a prohibition on that in the municipal land use law. But there is also a provision in the municipal land use law that provides, in the absence of another attorney serving the HPC, by default, the municipal attorney is serving the HPC. So you're probably not used to seeing me here in this context, and I just wanted to explain that.
Okay, so you're appearing on behalf of the HPC.
I'm not here on council business.
Okay.
I'm
Respect.
purely filling in for Mr. Feinberg.
Okay.
And who had a legitimate absence, obviously, tonight. So just on that limited issue. And I have been involved with Mr. Chicanis and the litigation at court. I think he's being diplomatic in his characterization of this, but really the question is the city talking out of both sides of their mouth? And I think the answer to that is simply no, and I can explain to you why. This was originally deemed incomplete based on Mr. Hurlis's letter and simply requesting resolutions and plans. Now, I'm sure all of you have read that transcript, and really the heart of that request in that transcript is, well, we have an approved, or we have a finished product here, and, explaining how they got there. And they're presenting that to the board and saying, please stamp this today, even though it deviates from the 2018 resolution. And I think in order to, in addition to that falling under, I think, a basic principle under the rules of evidence, the rules of evidence are relaxed here, but basic things like cross-examination of witnesses, basic due process rights happen here because you're a quasi-judicial body. I think one of those basic things Mr. King highlighted is the concept of judicial notice. And, there's a court rule on that which kind of incorporates common sense. Like, we don't have to quarrel about things that are just not in dispute. Prior approvals and resolutions, not only are they provided for in NJR Rule of Evidence 201, it talks about ordinances, regulations, and determinations of all government subdivisions and agencies thereof, that's the zoning board. Specific facts and propositions of generalized knowledge which are capable of immediate determination by resort to sources whose accuracy cannot reasonably be questioned. I think that's resolutions, decisions by government agencies. And in this case, turning to Rule of Evidence 202, and again, it's relaxed, but this is just kind of a common sense principle. Even on appeal, the reviewing court may take judicial notice of any matter specified in Rule 201, which is all those things I just listed. So you don't, as an appellate judge, you don't need to sit there and question whether the sky is blue. You can take judicial notice of those types of things. And in this case, I think prior approvals and plans that are sort of teed up for the HPC to say, please approve this, this is what we did. I think that's not only relevant, but it's kind of incorporated in that discussion. And to provide the documents that back that up is really a judicial notice issue. I think I think the applicant would be in kind of an odd position to not have those be part of the record. It's almost like they don't exist. So I have approval, but where is it? You have approval, you have plans, let's see it. And I think that's what was presented to the HPC. So in that context, I don't see the general request on a checklist, which is really not discriminatory to the applicant, to provide these things. I see that as a across-the-board type of request. It's something you can take judicial notice of. I think it's relevant to the heart of the discussion on the record about, what was approved, what wasn't, what do you have today versus what did you have in 2018. So I think all that's kind of baked into the discussion. Now contrast that with the expert testimony that's proposed tonight. The HPC didn't have that. They didn't have that to consider, the new testimony. But the thing that we do have is that ordinance was out there, was adopted in 2017. It was effective January 2018, the one that Mr. King had read. So by the time we get to 2020 and the applicant appears before the HPC, they're on notice of that code provision that, just like when people come here for applications not of this type, you get your shot to make your record, and if, that's your time to make the record, the next step's court. Well, they're on notice of that by the time they get there, and they were ready. They had counsel by their side, and they had a historic expert, which is evidenced in that record, and they engaged in a discussion. HPC came to a different determination, as is, I think, their prerogative. So, but I don't think we need to get into, I think, to summarize, I think the resolutions and the plans is kind of like basic stuff that I think you can take notice of versus, and not subject to dispute. I mean, those are the things that they submitted versus expert testimony, which is you never take judicial notice of that. That's always, you see experts come in here all the time, and sometimes they have competing opinions. So that's not really something that we can just take judicial notice of. And for that reason, I don't think it should be part of the record. Not because we're devastated by what's in the report or what it would be. It's just not part of what the record was.
I'm still not, I thank you, but it sounds to me like there's quotes in here. Mr. Copeland says on page 27, we spend a lot of time and energy, and we have a plan in front of us, and we make changes and modifications and discussions. I can't believe the HPC didn't have these plans. I mean, he's talking about looking at plans in the transcript. So aside from those issues, I'm just not sure that these really are supplements to the record. I mean, the plans of what was approved and the plans of what were built, that wasn't with the HPC when they...
The as-built, I can say for certain that the as-built plans were, because that's what we were trying to get a certificate of appropriateness for.
Yeah, so I mean, I guess I'm
We-
not really, I think I think that was a supplement to our record in a sense, but I think that's just because we didn't get it from the HPC, but it doesn't mean it was a supplement to the HPC's record. I think it was stuff that Craig didn't have, that he wanted to have, but I'm not sure the HPC didn't have it.
Well, I can, again, I wasn't there, but I can quite confidently say that the HPC didn't have it simply because the applicant didn't feel it was relevant. What had been approved prior was not the question. What was built now and whether or not that met with the design standards was the question. So the plans that were submitted were the plans of what was built. And again, it was our position that what had happened in the past happened in the past. We did provide some testimony to provide some context as to what brought us into this position, but that was beyond, that was pretty much the question. Do the as-built meet the standard or not?
Wasn't the other plans with the HPC the first time they were at the HPC?
That's a big question simply because the applicant was not aware of the, you see in
That's our architect
you
wasn't
see in
our
the
architect.
transcript that with the architect acted independently without my client's knowledge and consent. It's a very long and attenuated process that brought us here.
Okay, well, everyone's heard the positions. I mean, if my opinion matters or that you make the decision, I view them as qualitatively different items. Having the court saying that Mr. Hurlis, who requested the original plans and the as-built plans and prior resolutions as part of doing his checklist review, and the court saying, yeah, put those things into our record, personally, I'm not sure that is a supplement at all to the HBC's record. I think that those things almost certainly were in the HBC's record at some point. But even if they weren't, those are things that you can look at the plans, and they are what they are. You can look at the resolutions, and they are what they are. But testimony from an expert, they're supposed to be, that's a different animal altogether, in my opinion. That is stuff that normally would be something the HPC could hear and analyze. There could be cross-examination. The HPC can ask them questions to get answers, elicit additional information, be critical of their information, which, by the way, you saw some of that in the transcript. That's what's supposed to happen. So I don't view Judge Blee or the city's position that those items that are in that order should be provided, or Judge Blee's direction that those orders be provided as an invitation to reopen our record and disregard our ordinance and take in new testimony that the HPC never heard. That's my opinion. I'm giving you my opinion because I think I'm supposed to, but I don't vote. So I would recommend that a motion be made to allow supplement of the record with the expert testimony. And that's the motion to be made. If you think that testimony should be heard, you vote yes. If you think it shouldn't be heard, you vote no. And that's the motion, and unless someone feels a different motion should be made, I think that's,
Well, I don't know, I think we ought to be more positive, make the motion that it should not be heard.
okay, well, we usually do it.
I know we usually do the other.
Do it however you want. I don't make the
To make
motions.
it clear to everybody.
If you want to make a motion, sir, you
Sure.
make the motion.
I will make the motion that we not hear expert testimony at this appellate hearing this evening.
Okay, so if you vote yes, that means you don't hear the testimony.
Exactly, that you.
Yeah,
you
okay, I'm
will
just
not
making
hear-
sure everybody understands that because it's
Don't
confusing.
hear it.
That you
Yeah,
do
that's
not hear
fine.
it. If you-
We'll do
a
it that
yes vote means you voted not to hear testimony, right?
I like my way.
Okay,
Confusing.
Yeah,
Can we do it the way Rich said, so that everybody's
All right, okay,
on
do
the
it the way-
same?
That way you
Because
can say
that's
no.
always the way we've
just
done
wait,
it.
just so we understand that we're voting whether or not to hear testimony tonight.
Okay, I'm gonna
Okay.
say it again, so we're clear. Okay, there is a request to supplement the record with expert testimony. Okay? So the motion is a motion to allow to supplement the record with the expert testimony. If you vote yes, then they can give that testimony. If you vote no, then they cannot give that testimony. Does everybody understand that?
Okay.
All right.
I'll make that motion.
Thank you, Mr. Ryan.
I have a question, Rich.
Well, let's get a second and then we can discuss.
I'll second.
Okay, there you go.
Question in my mind, what we'll hear tonight, expert testimony, the HPC has not heard, is that, do I
Yeah, they want to put on
understand?
testimony the HBC has not heard.
Has not heard it.
Yes, and it's not even the same person that testified, it's a different person.
And so what we're being asked, let's carry it one step further, what we're being asked is to support an appeal, knowing that the HPC has not had all of the evidential matter.
That's what you're being asked to do. You're being asked to review their decision with evidence they've never heard.
Are we ready for the vote? Okay. Motion by Mr. Murray, seconded by Mrs. Notch. Mrs. Werner?
No.
Ms. Hessel?
No.
Mr. Ledwin?
No.
Mrs. Notch?
No.
Mr. Walsh?
No.
Mr. Murray?
No, again, a no means we do not want to hear the testimony. Is that correct?
Yes.
No.
Mrs. Hutchinson?
No.
Thank you.
Okay, the next issue you're going to consider, you're going to hear legal argument on why the applicant believes the decision of the HPC was arbitrary, capricious, unreasonable, and all the other things in the standard that I read to you, and they're going to present legal argument on that. The attorney's going to do that, and I presume Mr. Gillensworth is going to do that as well. Mrs. Canis?
Yes, I'll start. Good evening, Madam Chairman, members of the board. We do thank you for your time here tonight, and I probably should have said that earlier, but better late than never. Just to briefly introduce myself again, my name is Peter Chicanius. I am an attorney at the law firm of Highland Levin Shapiro. My office represents the appellant here, Locale Stockton LLC, with respect to this appeal of the Historic Preservation Commission's, I'll call them the HPC from here on out, their decision to deny a certificate of appropriateness for the completed Locale Hotel located at 5 Stockton Place here in Cape May. With me, as I said, are the owners of the hotel. They're here with me, Mr. and Mrs. Chad and Courtney Ludeman. And of course, we did offer to present Mr. Barton Ross as our historic expert, but obviously our application to supplement the record has been denied. So again, I'll just briefly, this might be things that the board is familiar with. They might not be. I don't know how familiar the board is with this beyond the transcript, but at this point, I think it's safe to say that this case has gotten a little bit out of control, a little bit kind of kooky in how it happened and really how it brought us here today. We're here today, hopefully, to really kind of clean up that mess and to do it here tonight, or at least part of it as best we can. And in doing so, hopefully avoid the need of any further litigation in this matter. It's one of the reasons why we brought a court reporter here, was to, in anticipation of the potential that this might have to go back up to court, although again, we're hoping that we don't necessarily have to do that, and we can potentially resolve this issue here and now. And the only question that Locale is asking the board to answer tonight, and it was the only question that Locale asked the HPC to answer the night it made the decision that which we're now appealing, is whether or not a certificate of appropriateness should have been granted to the completed Locale Hotel as it stands today. That's the question. In the applicant's opinion, the HPC was simply not interested in that question. Rather, the HPC was more interested in dredging up events that had already occurred, obviously could not be changed by anybody, in order to justify its refusal to fairly consider whether or not the completed building met the design standards of Cape May's historic district. And that's where we believe the HPC acted arbitrarily and capriciously and made its mistake. And we hope that's the decision we can rectify here tonight. When we were before the HPC, the applicant presented the testimony of 2 witnesses. First was Mr. Ludeman, again, one of the owners of the hotel, who is here tonight, and Mr. Primavera, who was our expert in the field of historic architecture, and who testified, in his opinion, that the completed hotel, as it stands today, does indeed meet the design standards of Cape May's historic district. To use his words, quote, this is certainly an appropriate building in mass, scale, rhythm, materials, and detailing for the setting. But once again, it's the applicant's opinion that the HPC was simply not interested in that question. Mr. Ludeman's testimony, who then testified first, again the owner, was really designed to advise the HPC of how they got there. How is it that a building managed to be constructed to completion in the historic district that didn't have HPC approval? Well, allegedly, it did have HPC approval, but it was alleged that it was not constructed in accordance with that approval, in particular the August 2018 resolution. This is a fact that was not caught by anyone until after the building had been completed, and if someone did catch it ahead of time, the applicant was not told of it until after the building had been completed. Mr. Ludeman's testimony was simply intended to fill that gap and to advise the HPC that the applicant didn't just, advise the HPC that the applicant didn't simply ignore them and say, okay, here's this approval, but we're going to build what we want. Really, what it was designed to demonstrate to them is that their architect is simply, and to use Mr. Ludeman's words, had gone rogue. He was a bit of a rogue architect, and his appearance before the HPC, the night that led to the August 2018 resolution, was not authorized by the applicant, was not done with their consent, was not done with their knowledge. So when they went to construct the building, they submitted permits based on what they thought they were building. It obviously didn't comply with what the HPC thought was going to be built, and something got lost in the fold. It wasn't, again, simply a matter of the applicant saying, we don't want to build what they want, we want what we want, we're going to build what we want and hope nobody catches us. Because if I had been involved in that process, my office wasn't at the time, the red flag would have been waving at that point because they'd find themselves, in my opinion, in the position that they're in right now. But again, that's not what happened here. The architect acted without their consent, without their knowledge, and essentially placed them in this position. And obviously, the applicant is no longer working with that architect.
Mr. Chicanis, they had conceptual approval at the first time they went to the HPC, right?
2017, I believe,
And
yes.
they don't claim that they had final approval at the time, they had conceptual approval.
Yes, in 2017, they had conceptual approval. The architect acted independently in pursuing what he saw to be final approval, and obviously my clients are not as well-versed in the process and didn't know what was happening. They weren't even in the area at the time.
So their belief was that they weren't aware that their architect had gotten final approval at that hearing because he went rogue.
Yes.
Okay. When did your applicant, when does the applicant think they received final approval?
When does the applicant believe they received final approval of what?
Well, they knew they had conceptual, but when did they believe they got final approval in order to get a building permit? If they didn't know that their architect,
When they got the building permits.
but they never went back for final approval. They had conceptual, but what event when did they go back to the HPC to get final approval from the HPC? Because in the record, when they were before my planning board, my recollection is they said they had HPC approval, but we'll leave that aside. But when did as I understand this transcript, is they said we got conceptual approval from the HPC.
Yes,
Then our architect went rogue and got final approval, and we didn't know that.
yes.
So when did the applicant think they got final approval from the HPC so they could get a building permit?
I don't think the applicant ever particularly had that thought, simply because, again, my clients, any developer, any applicant, any client of mine, they hire the architect, myself, because they're not as well-versed in this process, nor can they expect it to be experts in it simply upon reviewing the ordinance. So I can't say specifically that my clients ever had a particular moment where they knew final approval was obtained. They simply submitted for building permits and got them, and then built was in accordance with those permits. That's why they thought they had final approval, and they thought they had final approval to build what was built, because nobody once, as the building was being built, brought up, this is not being built in accordance with the HPC's resolution.
But there had to have been plans for you to be able to get permits. There had to have been plans. And on those plans, whenever we see them, and unfortunately we didn't see them, there's a list of materials and things that are supposed to be used. The architect, I mean, they had to have been on file with all that on there.
There's a disconnect here. I'm not refuting that point. When Mr. Ludeman was trying to say was not simply the applicant discarding the HPC. Something went a little off here. We're not trying to really rehash that issue much right now. If that has to be rehashed in court, that has to be rehashed in court. What we said, okay, what happened, whatever it is. My clients didn't know. The architect went a little rogue. Obviously, they are no longer in business with him. And so what they did was, listen, we have a completed building that we've invested time and millions of dollars into building. It is now built. It's completed. It has a TCO. When we applied for our CO, that's when it was brought to our attention, by the way, you're in violation of several provisions of the HPC resolution, to which my clients simply, not putting words in their mouth, but basically it was what? We're not in compliance with what happened?
So
There's
can
a-
I ask a question here?
Sure.
Just to clarify. Your client spent $5 million.
Millions of dollars, yes. I don't know
Millions
the
of
exact
dollars.
number.
Well, I think that was in the transcript.
It's-
So they went to HPC in 2017. They understood that that was a requirement of the process. In 2018, their architect goes off, does whatever they want to do, builds a building, completes the project, $5 million later, and unfortunately for them, either not present or not understanding the distinction between, final approval versus, something that was conceptually approved. Then comes back and is asking us to sort of interfere in that problem. I mean, I feel like we're being asked to sort of intercede on something that unfortunately was a bad business decision, and now it's coming before us to sort of problem solve.
I wouldn't say it was a bad business decision. Again, where this should have been caught, I don't disagree with the board in the sense that this probably should have been caught much sooner before the building was built. My clients had to submit plans to the construction office in order to obtain the permits that they received. They received every single permit based on the plans that they submitted. It was only, again, after everything had already been done and built, the temporary certificate of occupancy had already been issued, allowing them to actually open their doors, and they have been open since that time under the TCO. It was when they went for their final CO to finally put this one to rest that somebody brought up there are some violations of the HPC's resolution. And again, at that point, my client, the only choice that they had at that point, again, that's why I disagree with the characterization that it was a bad business decision. It was somebody's mistake. What we are trying to submit here is that it wasn't my client's mistake, and nor did they, again, simply disregard the HPC's approval, which seemed to be the opinion of the HPC. Again, I'm not going to put words in the HPC's mouth, but that seemed to be the instinct of my clients upon that hearing, was that they simply didn't accept that testimony. But again, it wasn't offered. And
Mr. Chicanis, before we leave that thing, and excuse me, I'm mostly a litigator by practice, but on page 57 of the transcript, the disconnect for me is that your client got conceptual, knew he had to get final.
well, that's what I'm disagreeing with.
Yeah,
I don't know that my
this is why I
clients
disagree with your
necessarily knew they had to
disagreement.
get final.
Page 57, Mr. Ludeman says, I just want to mention there seems to be some confusion on the original meeting, the conceptual meeting. Our architect presented 2 railings. I believe he may have presented 2 different stair types. He had some black and white elevations that had different options than some color renderings. So that's why we didn't, at that meeting, solidify all the details. And it was put on the record that we were going to do so in the final meeting, whether that was administratively or in a future hearing. So in this transcript, he acknowledges that he had a conceptual, there was some question about how the railings were going to be, and that was going to be done at a final meeting when they get final approval. He then, hold on, let me finish. He then says that his architect went, without him knowing it, and somehow they got a building permit but never got final. But he says here he knew he had to go back and get this straightened out with the HPC. When does he think that happened? If it wasn't his architect going there?
Think about the timing of that transcript. After that, everything had already happened. At that hearing, obviously, the applicant was aware that the architect got final approval without their knowledge and consent. Obviously, at that point, they were aware that final approval was obviously necessary. And from that point forward, okay, it was obtained arguably illegally, which is a separate issue for the court to decide. But at that point, obviously, the applicant was aware, based on that date in January.
He's saying he was aware at the conceptual meeting that
I don't-
the reason they didn't, they write these things down. It says, I just want to mention, there seems to be some confusion on the original meeting, the conceptual meeting. Our architect presented 2 railing types. He's talking about what happened at the conceptual meeting.
Understood.
I believe he may have presented 2 different stair types. He had some black and white elevations that had different options than some color renderings. So that's why we didn't, at that meeting, meaning the conceptual meeting, solidify all of the details. And it was put on record that we were going to do so in the final meeting, whether that was administratively or in a hearing in the future. So he knew something had to happen between his building permit and the conceptual meeting for him to know what the final plan was to move forward. And if he says he didn't know his architect did that, I'm asking, when did he think that happened?
Obviously, by the time he got his building permits, is my answer.
But-
When he got his permits, obviously, he was of the opinion, and justifiably so in my opinion, because I don't know that anybody should get permits if they're in violation of something. He got his permits. Obviously, at that point, my client was justifiably of the opinion. Final approval was obtained, whatever that might have meant.
Well, it was by his architect. But, okay, let's get to, I'm not
It's-
saying this is relevant.
That's
but it
the only
keeps-
reason
it
I
keeps
brought it
coming
up.
And you brought it up. I was hoping it wouldn't come up, but since it's there, we got to.
The only reason I brought it up, I think it would have been simply stupid of me not to. It's in the transcript. It covers a substantial portion of the transcript. The reason I brought it up was to clarify simply why Mr. Ludeman testified the way he did, which is simply to convey to the HPC and now to the board that it was not a matter of them simply discarding the HPC's resolution and building what they wanted. They built what they thought they were allowed to build. They got permits for it, which obviously gave them a very clear impression that they were allowed to build it, and that's what was built. The reason we brought that up was simply not to rehash that issue. We weren't seeking sympathy, and in fact, at least 2 HPC members said whether or not you had miscommunication or lack of communication with your architect is simply not our problem, which was their exact word. And Mr. Baranowski, the attorney at the time, but from my office, said they weren't seeking sympathy. What they were simply trying to do was explain at how the parties arrived at the situation in which they found themselves in an effort to encourage the HPC to do not what we're doing right now, which is focusing on the past, but to focus on the present and to answer the question that was before it, which was whether or not the completed building meets the design standards of Cape May's Historic District. That's the question that was asked of the HPC. That's the question that's being asked now, not what happened. And in fact, Mr. Feinberg himself, in the HPC on page 69, encouraged the HPC to remain focused on that question, stating outright, I don't think it's helpful to get into a protracted discussion about how this may have happened. I tried to avoid that tonight, and like that night, it didn't work, because everybody, I'm sorry, go ahead.
Well, I'm going to have that question too. I don't understand how someone with a building and a project that costs that much money would not be looking at those architectural plans and saying, this isn't what we had discussed, we've changed it substantially. Are you sure that everything is approved here? I did a project myself, was my own home, but I had my finger on it the whole time, and any minor little change I was aware of.
I'm not saying they weren't aware of
Find
the
that
changes.
hard to believe.
I think what they weren't aware of was that there had been a final approval independent of, again, they weren't there at that hearing. My clients have been at literally every hearing before and up to that point. They weren't told. They weren't even in the area. And one of the other big items, and again, this isn't really before the HPC, the board, but I'll make it known now, is whether or not that hearing should have happened at all. Because any applicant, LLC applicant appearing before any board, whether it's a zoning board, planning board, HPC, is required to be represented by counsel. Counsel was also not there, further bolstering the idea that, yes, he kind of went off the rails, did what he thought was best for the applicant without telling them. And it depends on the applicant. I can't speak to everything, but some applicants do place a lot of trust within their professionals. Sometimes that trust is misplaced. That's really what we're saying happened here, is that their trust was egregiously misplaced in that architect. But again, I don't want to necessarily get bogged down in how that happened.
I'm going to give the board the instruction I always give them on every application when this comes up. So you've heard me say this before, I'm going to say it again. In my opinion, whether or not the requested project has been built already or not, or built illegally, is irrelevant to your determination. Now, sometimes applicants want to talk about it, and they want to make it sound like it's the city's fault, and that's okay, but then they're going to get some pushback for that, but that's how it goes. But it doesn't make it relevant. So, as I've told you before, you're to make a determination on the standard that I read to you. You should disregard whether it's been built or not built. I mean, we even just had this a couple weeks ago. I may have said the same thing. So you are to listen to the testimony that was below regarding the design standards and the HPC's view of it and their experts' review of it in the transcript. Then you're to apply the standard that I read to you, and then you make a decision. And I'm directing you to disregard whether it's been built or whose fault it was that it was built. Judge Blee will make that decision in an estoppel hearing, presumably in court. I guess that's how that'll go. But that's not what you're here to do today, okay? So we went through that little exercise because I think that there's some disagreement on how that issue is presented, at least from where I sit based on the transcript. But that is not really what we're focusing on. So I would ask council and the board to focus on the testimony that was given on the historical preservation guidelines, the stuff that they believe should be built. To some extent, what is there is relevant because people are talking in the transcript about if what is there is consistent with the standards, so you can't ignore that it's built, okay? But I don't want you to punish them for having built it, and I don't want you to give them a break because it's built. It's irrelevant. So you have to consider what's there, because their expert says what's there is perfectly fine. So you can't ignore what's there, it's there. But apply the standard to the facts in the record and just do that. Don't punish them for having built it, and don't give them a break for having built it. You understand?
Okay, yeah, I agree. And I think what we're looking at tonight, we'll forget all that stuff, okay, about I agree with you. Okay,
And very
we're
quickly,
we're looking,
I'm sorry to interrupt. I just want to make one thing clear.
Sure.
We're not blaming anybody.
Oh, no,
One thing
I understand
said
that.
was something got missed. We don't know who. We're not making any claims as to who dropped the ball where.
I understand, that's not within our purview anyway. So what we're looking at, okay, what happened, from what I read the transcript, is after hearing the applicants and expert testimony, okay, the HPC determined that the building is in the historic district and is a contributing building, okay? And as a result, okay, they said the completed building does not meet the design standards. And as a result, they denied the issuance of a certificate of appropriateness. Is that correct?
I would characterize it a bit differently, and if
Okay.
you'd like, I can tell you how.
So what we're looking at here and what we're looking at on appeal is whether or not in making their decision, they were arbitrary and capricious,
And unreasonable.
right? Okay. So that's the way it boils down to me, is listening to and reading the transcript, finding out what they did, okay? They listened to testimony, they made their determinations, okay? And after looking at it, we'd have to decide, is what they did arbitrary and capricious, okay? And I think that's what it boils down to. Am I correct? Okay.
And so why don't you tell us
But
why
that's,
the
I'm about to
HPCs
jump
Yeah,
in there
okay.
now. Again, I just wanted to kind of, thought it would have been foolish to ignore what it makes up at least half of the transcript, so that's why I addressed it there. But I'll get into the design standards now, particularly Mr. Primavera's testimony, who testified after Mr. Ludeman, and discussed, and again, one thing that he did conclude was that the completed building does, in fact, meet the design standards of Cape May's historic district. Again, to quote him directly on page 56, "This is certainly an appropriate building in mass scale, rhythm, materials, and detail for the setting." And in fact, he began his position by calling into question whether or not this building should have been deemed contributing at all. Now, per the Cape May website, it describes briefly for anybody who might be interested what contributing means. And what contributing means, according to Cape May's website, our contributing structures, are those whose architecture enhances the neighborhood where they are located, but the style is not unique, meaning that there's other buildings with a similar architectural style, but it enhances the neighborhood and the setting in which it's located. Mr. Primavera essentially challenged that assertion, that the building should have been contributing at all. And again, right from the get-go, it became pretty clear that the HPC seemed to have very little interest in what Mr. Primavera had to say, based on whether it was his expertise or his substantive testimony. Thankfully, he was accepted as an expert in the field of historic architecture, and in fact advised the HPC that he was actually one of the academic advisors to the National Park Service when the possible de-designation of the Cape May Historic District was considered. That's on page 34 through 36. So that's clearly Mr. Primavera was familiar with Cape May and its standards at the time of his testimony. He began his testimony with the previous building, stating for the reasons that he expresses in the transcript. I'm not going to go through each and every single one. Each of you have clearly read the transcript, so you're familiar with those reasons. But what he concluded was that the building was not and should not have been considered a contributing building. He said that designation, he testified, was made in error. You can see, again, that conclusion and the reasons on page 41 and also on page 44. Those are just some examples. There's other spots as well. And once again, then the HPC didn't seem to really hold his opinion in any level of regard, simply dismissing him, saying it's not helpful to talk about whether or not this is a contributing or non-contributing building. As far as we're concerned, it's contributing. Contrary to the HPC's assertion, and then Mr. Primavera's opinion, however, whether or not the previous building, the one that was essentially a new building was constructed, really, but we'll call it rehabilitation for purposes of this hearing, whether or not the previous building was improperly designated as contributing is absolutely relevant to the discussion, and in fact should have informed the entire discussion from that point forward. But because that discussion may have led to the conclusion that the building could remain as is, the HPC shut down that conversation before it was even permitted to start, even though one of them admitted outright that erroneous designations of contributing buildings does happen. but the simple possibility of this being one of those times was not even entertained. Mr. Primavera then described the standard that he believed should have been employed for the construction, stating that according to the Secretary of Interior standards, which Cape May has largely adopted, the standard here should not have been rehabilitation, but new construction. That's on pages 47 through 48. And the reason for that was because, quote, what was approved in concept was by far not a rehabilitation. This building had to be picked up and moved. It had to be partially demolished. Foundations had to be redone. Ceiling heights were raised. All of the finish and siding was changed. All that was left was the basic rectangular form of the building and the fact that it has two full-length front porches. Other than that, this is a new building, and it's my professional opinion that the HPC would have been better served to have reviewed this project under the Secretary of Interior standards for new construction, not rehabilitation. Mr. Primavera continued, new construction, quote, allows for a certain amount of contemporary design to be done that's not trying to falsify history, that's not trying to create a Victorian period building out of a building that no longer represents that style or has that integrity in its architectural design. Once again, the HPC was simply uninterested and well, I won't say unresponsive, they were uninterested. And it was really here, in the applicant's opinion, where the true motivation behind the HPC's decision to deny the application began to really kind of show itself. Because one HPC member responded to that very assertion, it should be new construction, not rehabilitation, saying as follows, whether it's new construction or rehabilitation, does an agreement to put a Chippendale railing change? And that's on page 51, and there was also another assertion on page 82. The issue was there was an agreement to do a bridge stair. And again, these are just examples. I'm not going through every single one in the transcript because, for the sake of efficiency. But that right there informs the HPC's entire motivation in denying Locale's application for a certificate of appropriateness. Mr. King just said to you guys, don't punish them for it having been built. Don't cut them a break because it was built. The question before you is, does the building meet those design standards? What I'm submitting here is that's not the question that the HPC answered. Instead, in the HPC's mind, they had already decided the issue, whether the applicant was aware of it or not. There had already been an agreement, quote unquote, between the HPC and Locale's rogue architect, as we're calling him, that was not complied with, and the applicant must reap what it has sown. The HPC was not interested in whether or not the current building met Cape May's design standards, which was the only question being asked of it, but rather seemingly in punishing Locale for, in the HPC's mind, building what it wanted, rather than what was approved. The HPC's refusal to address the question being asked of it necessitates a finding of arbitrariness and capriciousness, which is the standard, of course, by which the board is to make its decision tonight. And the actual aesthetic choices that the HPC is attempting to impose upon Locale only further bolster this conclusion. For example, as Mr. Primavera noted during his testimony, regardless of any agreement regarding the Chippendale-style railing, Chippendale is an 18th century furniture style. Chippendale is not a Victorian period architectural style. Thus, the requirement for a Chippendale railing was clearly arbitrary and capricious, as it failed to invoke the time period that the HPC was required and is alleging it was trying to preserve. The same is true, in fact, of the clamshells. According to Mr. Primavera, clamshells are, quote, a traditional way of paving in the historic districts all up and down the New Jersey shore and eastern seaboard of the United States. And one HPC member actually took issue with that statement, saying, quote, I would take exception to places like Cape May. Clamshells are not approved in the district. As that HPC member had to be reminded, that is in fact not correct. Page 64 of the design standards specifically allows what Locale has installed, saying, quote, new driveways and parking areas should be paved in materials that are compatible with the historic character of Cape May. Appropriate materials include crushed clamshells and oyster shells. When presented with this information, the HPC didn't address whether or not it's permitted or not. It simply fell back on prior practices, saying, well, we have not approved, and quote, we have not approved clamshells in the last 15 years, which respectfully is not the question. In fact, one of the board members, in deciding to deny Locale's application, stated that this has become a Western-styled building now. That's a quote. Given that the building, as Mr. Primavera testified, maintained its rectangular form and its porches, The only item that could remotely be characterized as Western would be the color, which is obviously not pastel, but more of a brown color. Interestingly, Cape May's own website states verbatim that since Cape May, quote, is a composite of architectural styles representing several eras, bringing a wide spectrum of colors used through these periods, the HPC does not rule on exterior color. Yet that's what it did here, in characterizing this as a Western-style building. Then, as a final example, there's the roof. While the HPC recommended a standing seam metal roof, the design standards do not indicate that standing seam is a historically appropriate roofing material. Tellingly, in fact, asphalt shingle roofing, which is what we have here, is identified on page 54 of the design standards as being appropriate even for contributing buildings. And in fact, a visual observation of the surrounding neighborhood indicates that almost every single house in the building along the adjacent streets has asphalt shingle roofing. And as testified to by Mr. Primavera, the surrounding properties and overall setting in which the building is located absolutely plays a role in the appropriate materials to be selected. Per his testimony, one of the reasons he was of the opinion that the building was erroneously designated as contributing and why the new construction standards should have been applied to this project was the setting. He testified, and quote, "What's across the street is a modern brick building made of cinder block. What's adjacent to it is a hotel that was built in the 20th century. What's adjacent to it is 2 new houses that were approved by the HPC that were built within the last 3 or 4 years. There are none of the defining elements of the Cape May Historic District that we all know and love in the setting of this building." Thus, and I'll summarize very briefly, the HPC's decision was arbitrary and capricious not only because of its refusal to actually answer the question being asked of it, instead focusing on the alleged prior approval and whether or not that was complied with, but also because of its failure in that prior approval to actually adhere to the design standards. In the applicant's opinion, the HPC members were less concerned with the design standards and more concerned with what they subjectively liked. A perfect example of that being the Chippendale railing, which again is not part of the Victorian period, but is in fact 18th century, according to Mr. Primavera, and the fact that one HPC member wasn't even aware that clamshells are perfectly acceptable materials within the historic district. So, and I think, well, I'll cut this out given that we already decided on the other particular item, but in sum, it was Mr. Primavera's position based on very clear and particular points dealing with the clamshells, the roofing, the siding, the color, that this building, regardless of what happened, regardless of the original resolution, what happened in between, where the ball was dropped, this building now, the building as built, meets the design standards. And he demonstrated in his testimony, and obviously there are more examples than what I gave. Again, I didn't want to go through literally every single scrap. The board is obviously familiar with the transcript, and they've been provided with a number of materials related to this. The question before the HPC was, does this building meet the design standards? Mr. Primavera said yes. And it was asked earlier, didn't the HPC make the decision that it in fact does not meet the design standards and therefore they're not going to approve it? The applicant respectfully submits that no, that's not the question that they answered. They ignored that question. The question that they asked and answered was, does this comply with our August of 2018 resolution? The answer is no, therefore no certificate of appropriateness should be issued to the building as it was built. Again, it was more along the lines of, the HPC seemed to be of the belief that the applicant had dug this hole for themselves, and now they have to wallow in it, which again was not the question, nor was it the HPC's real prerogative to impose that on the applicant. So we would submit, and I would reserve the right to respond to Mr. Gillen-Schwartz should the need arise, but we would submit again that the HPC's decision was arbitrary and capricious, and the as-built building does in fact meet with Cape May's design standards, and as such, a certificate of appropriateness should be issued, allowing my clients to get the CO and finally put this issue to rest. Thank you.
Bob, can you just give the board a list of the items that are at issue?
Sure, there's
In
actually,
case they feel different about certain ones as opposed to others, I want them to be able
sure,
to
there was
go through each of your items of concern.
a letter, here, hold up. There's actually a letter from the HPC's member here. That's part of the record, I'll say that, because it's been submitted in court as well, they're familiar with it.
Take your time and just,
So just bear with me one moment as I kind of try and track that.
unless you're not interested, I just thought it'd be helpful to have a thing.
No, I don't
List of
disagree.
things, and I just want to make sure everybody has the same list, and
I don't disagree. I know it's in here somewhere. I just need to make sure I kind of find it.
I find it first, though.
It's a letter from February 22nd of 2022, I believe, is the date of the letter.
He's talking about some letter that came up through. It might be in the application somewhere.
I'm looking for it now. I know it's somewhere. February 17th is the one that I'm talking about, actually. Okay.
I have it here.
Chris, if you want to just, kind of take it from there.
Is it already in the packet somewhere, or is this?
Yes, it was submitted as part of the packet, for sure.
I'm not either.
I'm sorry, what's the date again?
February 17th.
17th.
All right, well, let's not put that in evidence. Let's just, if you can use that as a little help to do the list, then that'd be a better way.
Yeah, sure, if you want
I
to.
just have it on the laptop.
Yep, sure, go ahead.
Would you like me to read it, Mr. King?
Oh, yeah.
Well, actually, you know what? I have the resolution itself, which
Yeah,
kind of goes through it.
I was looking at the resolution. I didn't quite get as clear a list out of that as I,
Well, here, I think these are the item, and it kind of goes through the HPC, the reason that the applicants, the action of the HPC are as follows. The applicant has previously received conceptual approval. The final application has made two changes, rail detail and stairs. So the
Yeah.
Chippendale railing and then the ridge stair. The subject property has been modified over the years. The proposed reservations are an improvement. The proposed railing system is too contemporary. Chippendale style was requested. Retain the original front stair bridge design was requested. Other materials to be used will be a standing seam metal roof, which was the roofing that we
remember
discussed.
there's a transcriber for this one. She's trying to write down what it's saying.
I talk extremely fast.
When we're
I'm sorry
reading it,
about that.
it's harder. I probably-
And just as a byproduct of my profession, when I read, I skim. And it only enhances the speed in which I talk. Do you want me to repeat anything, kind of take it from the beginning? Sure, okay. So again, this is in the original resolution dated August 18th or 20th of 2018.
August 20th, yeah.
August 20th, okay. The applicant previously received conceptual approval. The final application has made two changes, rail detail and stairs. It goes down to subsection C on page 2 of that resolution. The proposed railing system is too contemporary for this building. The applicant has agreed to redesign the railing system in the Chippendale style, which again, according to Mr. Primavera, is not actually appropriate in the Victorian period. The applicant has agreed to retain the original front stair bridge design, which was another item. Other materials to be used will be a standing seam metal roof, which was the roof thing that I discussed, less than 1/2 inch. Anderson Woodwright 400 series windows, wood doors, brick foundation, wood fences, IPC decking. Applicant has agreed to use all cedar clapboard siding. No AZEK will be used, rather wood materials. Applicant will submit lighting plan, foundation pavers, sealed architectural plans to review, and it goes on. But those were the particular items that were being addressed.
So this is the 2018 resolution we're reading from?
Yes.
But the appeal's from a 2020 resolution, right?
But again, our position formally, and we think there's a fair amount of support for it, was that the applicant wasn't, the HPC wasn't interested in the building as built. They relied on this to deny it, which wasn't the question. You didn't comply with this, therefore you're not getting your approval. That was the question that they
So
answered.
I'll go with this list. So I have the railing system,
The front
stair,
stair bridge
metal
design,
roof.
the metal roof, the 400 series windows, wood doors, brick foundation, wood fences, and IPC decking.
Can I say something? Wasn't there a breeze block wall involved in this, too?
There is a bleed rock wall involved in this as well. And of course, the clamshells, which was another matter.
Can I just clarify for some, when you were going through the justification for why HPC should be considered arbitrary and capricious, I'm a little confused. In one point, you're talking about the expert testimony of the gentleman indicating that this was never a contributing building, but then he testified that it met all the design standards. So which argument are you trying to make?
Well, they're all made in the alternative.
I'm sorry?
Well, it's essentially an argument in the alternative. So Mr. Primavera was of the opinion that, listen, this should not be a contributing building, and believed there was some support for that, which he then testified to. However, to the extent that the board did not, the HPC did not agree, and obviously they did not, he then addressed the design standards in saying, even if it is a contributing building, the building as built meets with the design standards and can receive a certificate of appropriateness.
Okay, railing, stair, metal roof, wood windows, block wall.
Brick foundation and wood fences. And I believe finally the IPC decking as well, which was the IPC decking was the final. And the clamshells, of course, which is not actually mentioned in here, but we know it was is an item.
The clamshells, my recollection is that the clamshells are prohibited by our parking ordinance, and then they requested a variance for clamshells. And because we allowed back-out parking onto a sidewalk, our engineer is the opinion that the clamshells could create a tripping hazard on the sidewalk, and therefore we denied the variance for clamshells and required it to be something other than clamshells, but then I think they did clamshells anyway. That's my general recollection of what happened. So I don't know that the HPC's opinion on that matters all that much, because there's an ordinance that says they can't do it, and we didn't give a variance, so
Well, we would agree the HPC's opinion shouldn't matter, but we would say the design standard should, which permits clamshells, which was the question before the HPC.
That was at the planning board?
Only in residential clamshells, correct? I'm sorry.
For the record, at the planning board site plan hearing, there was a request made for variance approval for the clamshells. That was denied, and Mr. Orlando and myself debated that in front of the board. And the board sided with me and found that the clamshells were inappropriate for back-out parking because the clamshells and the turning movements would push those clamshells onto the sidewalk, create a trip hazard. So the approved plans had pavers, brick pavers on them, and that was not what was constructed.
Did you also say that our ordinance prohibits clamshells in multi-dwelling
Yeah,
buildings?
so
That's
for-
what I thought.
You're correct. There was dialogue
Make any
and
difference for here.
that was had directly with regards to testimony for a variance at the planning board level with regards to the clamshells.
we have from Mr. Gillis, Madam Chair.
Yes, please.
I thought you were finished.
Yeah, I would just reserve the right to reply to the extent.
No problem.
Thank you, Madam Chair. I just want to switch gears for a second and maybe say something nice about the applicant as it relates to this transcript. I think it's pretty clear, and it's relevant to what the board has to determine here today. I think it's very clear that the applicant has a point of view, has a vision for what they wanted for that property, and maybe some others that they do. And I think that's a good thing. But I think the question that this board is being presented with is, to what extent can an applicant impose that vision on the city of Cape May and its historic district? And I think the record, I think, reflects that this was a contributing property. And it was contributing, I think it was because of the pursuant, this is in the resolution, this is resolution, the 2020 resolution. HPC finds that the building prior to the applicant's modifications was appropriately related as contributing, as detailed in the survey report. Specifically, the report notes it has the distinction of being one of only a few buildings constructed during the years of the Great Depression, a time when construction virtually came to a halt. With its two-story open porch, plain building was adapted to resort living and therefore can be considered a contributing building in the historic district. Every effort should be made to retain the open front porch and wood frame windows. And I think that's important for a couple reasons, but one of the main ones is the HPC's evaluation of Mr. Primavera. I think Cape May is widely known for its Victorian architecture, but anyone involved in the HPC, and I'm sure this board's familiar with, our period of significance does not end or begin with Victorian. It goes all the way up to 1940. So, and if you look at the design standards, you just read through them, there's tons of different periods of significance and different details. And I think the way that I see this is, I think that in this context, I think the applicant's pointing out, well, I made these changes, the building looks good, why are you harping on all these little details? And I think what the HPC ultimately said, I mean, they were, first of all, entitled to voir dire witnesses, okay? Ask questions and things like that, and sometimes those questions can be tough. But at the end of this, and when they take a vote and they explain the reasons, I think what you see is that the board is pointing to the idea that all these little details, and they may seem small when you look at them narrowly, but when they come together on a property, and when they come together on the entire historic district, that's what sort of contributes to the uniqueness of Cape May and contributes to the historic character of the town. And preservation of those little details and, you know, insisting on a Chippendale railing is exactly the type of thing that I think we have an HPC for. And it's not to say to the applicant, you have to go back and rebuild this building, okay? They have a TCO now, they're operating, and you know, hope business is good for them. But what we need is, you know, when a building is changed, according to their expert, approximately 90% is like gone and it's new construction. Well, the HPC is there to push back and say, we need these design elements in to preserve the historic character. And that historic character is informed by different periods, not just Victorian. And I think that's where really, when I was reading this transcript, where I think Mr. Primavera lost the board on a substantive level, because it demonstrated that he wasn't really even thinking about the design standards. You read the first few pages and it says, look, these are the periods, it's not just Victorian. So, and I think at the end of the transcript, I'll say this about what the board may do tonight. And because the 2018 approval has been sort of called into question as to how it was done, I don't really care, and I agree with Mr. Chicanis, I agree with Mr. King, and I agree with Mr. Feinberg in this transcript in that how we got there and did you know that this wasn't permitted is not a relevant factor here. It's like the HPC had to determine is what they have at that time appropriate. And then what you have to determine today is, did the HPC properly evaluate that application based on their design standards? Similar, but a little different. But I think the result of you affirming the HPC's decision is not to leave the applicant flailing in the wind. They have an approval. In 2018, they got final approval, and that was deemed appropriate by the HPC. They gave them a roadmap, and there's a few items on there, but it's not rebuild the building. It's, you know, and at the end of that transcript, right before they took a vote, they invited commentary and a discussion about, well, what are the alternatives here? Because what you're proposing now as built without our approval is not appropriate. So inviting that conversation, but the applicant, which is their right, decided to just go ahead with the vote, and it turned out the way that it did. But I think that the 2018 approval, I don't care when they knew. I think it's sufficient to say that I think they should have known when they went to the planning board a few months later after that 2018 resolution, because as it's attached it's part of the record for the planning board in that February 2019 resolution. The architect who's at issue here was testified at that. It's in the resolution, and the applicants were present for that as well. So I can see in the scope of a project, you're so focused on every other thing, and there's lots of things to focus on, and I'm not really concerned, and I don't think the board has to reach any conclusion about whether they knew. My point is, at that point, based on the discussion earlier, I think they should have known at that point. And if you should have known, it's really not on the city. It's not the city's error at that point. You know, that approval was there, it was available, it was incorporated as part of that record, and I think the applicants at that point should have known, you know, what HPC approval they were dealing with, because the planning board then relied on that, which is not really relevant here.
Mr. Commissioner, yeah, can I bring you back to the concept of arbitrary and capricious and the standards? Because this is what's confusing to me about this whole issue, is that in when they went there for conceptual approval, this resolution that my colleague here just showed me from September 2018, there was a list, a roadmap, as you just called it, of what was appropriate in the conceptual approval. And that had Chippendale in it. It had a metal roof in it. And at no time during that hearing, as near as I can tell, did the applicant or any of their experts or anyone say that those are inappropriate for this building. Okay, there was an agreement in 2018 that those were the things that were appropriate for this building. Then in 2020, the HPC is given new ideas from a new expert and of what would be appropriate. And I'm having trouble discerning how it can be arbitrary and capricious for the HPC to stay with the 2018 items that no one said were wrong in 2018 and say in 2020, we feel the same as we did in 2018. So it's not as if they came up with Chip and Dale out of thin air in 2020, or a metal roof, or the list of items in 2018. 2018, it seems like, as between the applicant and the board, there was a general understanding that those things were appropriate for that building. And now in 2020, what happened was, it seems, that the HPC said, we still think that what we all said was appropriate in 2018 is appropriate in 2020. And if we're going to ignore the fact that something was built in between, why is it, and maybe this is for Mr. Chicanis to say, why is it arbitrary, capricious, and unreasonable to stay with what everyone seemed to think was appropriate for the building in 2018?
I mean, I think what this really boils down to is a very, very clear disconnect between the applicant and the city. Because I would disagree with that characterization, simply that, again, I don't think that the HPC was saying we're going to remain consistent with the 2018 approval because we still feel that's appropriate. What, to me, it seemed very clear that the HPC was saying, we're not addressing the as-built building because this is what we said in 2018. That's what we want. Build this. They ignored the new building, which was the only question we were asking that night, which is, should a certificate of, now that the building has been built, regardless of how it got built or what got dropped, it's been built, is the building entitled to a certificate of appropriateness? And the applicant's position is that that question was never answered. They said, listen, we don't care about the new building. This is what we said we wanted, and therefore, that's what should be built. The fact that they refused to actually address the only question that was before them, to me, necessitates a finding of arbitrariness and capriciousness because that's the only question that was being asked.
Mr. King, can I respond to that?
Yeah, go ahead.
There was a lot of discussion about how they got there, but ultimately, when the board went to deliberate, there's a discussion about the building retaining its contributing character. The block wall doesn't fit, it's too modern for the area. I equate that with a late 50s, early 60s construction. That's page 102. That's from the design standards. It's period of significance 1940. Fence standards are vertical picket type fence. Again, that's 102. And, you know, I think the board is, when it comes down to it, there was a lot of discussion on that record because there was a lot of confusion that I think they were trying to flush out. But when it came time to make a decision, it's pretty clear that they were looking at this as whether it's appropriate or not. It wasn't, we're penalizing you because you built something and you didn't have, we think you didn't have approval for it. They know they're not the municipal court or code enforcement office. They evaluated it based on their standards, and they determined, no, we approved in 2008 something, an improvement to this site, and balancing with that elements that would preserve the historic district or contribute to the historic district. And these new things that are out there now are being denied, not because they're out there now without approval, but because they're a bridge too far under the standards. That's why. And that deliberation is in there. So there is a lot of stuff in there in the record, but ultimately when it comes down to it, I think the decision-making is rational. It's just based, and there can be differences of opinion on that, but that doesn't mean that what they did is arbitrary and capricious. They're evaluating it based on their standards.
Thank you.
I know that this is going to be appealed, so I'm sorry to talk so much, but I want to make sure the record is complete and make sure that you all address each item so that Judge Blee has a full record. So I just want to go through each item and make sure we understand the record and give them a fair chance on each item and give the attorneys an opportunity to respond, okay? So on the railing, let's just go right down the list, okay? So I mean, we cannot, but maybe some of these, they might agree with you, so I want to kind of,
No, I just want to make them, what I can say is limited. I'm limited, obviously, to the record. I'm not a historic expert. It'll be tough. That's one of the reasons why we wanted to have one, to kind of address each individual item and really kind of address it.
but we're not experts either, so I just want to tie them to
That's
the record below. That's why.
fair enough.
That's why the record below is important.
Fair enough.
So the railing, as near as I can tell, the viewpoint is that the HPC seemed to want to replicate to the greatest extent possible what was there previously, and it was their view that what ended up being built was not at all what was like there previously. Right? Isn't that,
No, I would disagree with that characterization.
okay, go ahead. Say, what-
Well, I had mentioned it
What was
before.
the standard that they misapplied regarding the railing, or?
Well, and Chris, Mr. Gillenschwartz, excuse me, had mentioned it in terms of what Mr. Primavera had said was that a Chippendale railing is not appropriate for a Victorian building, which is what this previously was.
I'm sorry, you're right.
Yeah, fair.
I
So
miss.
I went through most of them, I think. I didn't want to touch on every single one, but the record and the transcript
Let's
is.
just go through each one. Does everyone mind doing that, so that you hear what the reason is for each item, and then that's going to be, unless you have questions, then we'll do our vote. Is that okay? I mean, Madam Chair, does that make sense to
Yeah,
you or no?
that's fine. I don't mean to be, but this railing that's on the original building is not Chippendale. It's just regular,
I think that's okay.
That was one of the,
no, here's the original building,
This is the original building.
but that's not Chippendale.
Madam Chairman, I think you're touching upon what was Mr. Primavera's first point.
Okay.
That building should not have been designated as contributing. But again, that's part of the record. I don't want to rehash literally every part of my argument. That was one of the reasons, was that this building arguably should not have been designated contributing at all,
What railing do they want? What railing do they want?
the one that's there.
Which is what?
I don't know the official name.
If I may, I think I
Oh,
can,
it's this long stuff.
I
So-
think there was no railing. My recollection walking by is there were planters. No, I'm not sure.
no, I think, so I think the issue, let's start with the stairs, and then we can turn to the railing, if that works. Because what's there, obviously, is they have the painted things.
Rich, it might be easier, and I'm just going to throw this out there. Again, my clients are here. They can kind of testify as to kind of what's there in a better way that I cannot.
I'm trying to figure out what, the record below, they were choosing between two railings. What were the two railings they were choosing between in the record below? And that's what we have to decide, right, Bill?
Yeah, and they were talking about, starting on page 91, I think it was, they rehashed what their decision was to be made, okay? I think that's when the chairman brought it up and say, okay, we're getting ready to vote, say what you are voting on and what your reasons are. And I think a lot of it's there, okay? And again, specific kinds of railings, I think they discussed that. They talked about Chippendale and whatever it is. But I think they discussed all of that stuff, at least my understanding.
I'm not disagreeing with you there. That's why I'm telling you, Rich, these items were discussed on the record. I think to rehash literally every single one would be needless. And again, I can't do that from memory simply because it's in the record. It's in the entire record that it was supplemented, what was discussed, what was approved, what was built. It's all there.
To bring up the expert, they did listen to the testimony of the expert, and as we know, there's two aspects of an expert. One is whether you accept their credentials, and if you accept their credentials, then there's the weight given to the testimony of that expert at that particular trial or whatever it is. So there's two aspects. So the fact that they accepted the expert doesn't mean they have to agree with the expert. Okay,
Well-
that goes to the arbitrary and capriciousness, at least in my mind.
Sure. I wouldn't disagree with you there. Our position really is that they didn't, they did the one, acknowledged him as an expert, but then failed to provide any weight to anything that he said, and that was a predetermined decision.
Well, these members of the HPC are experts. I mean, if you look at our ordinance, which I did, I got our ordinance to come up with, the criteria for even becoming a board member is pretty substantial. So they are experts. So I think that, in my mind at least anyway, they're qualified to make a decision as to whether or not they should give this particular expert a lot of weight or maybe not so much weight.
Sure. I mean, the disagreement is very apparent between the applicant and the city, for sure. We're not denying that for a second.
board want a discussion?
Anybody have any questions?
Yeah, I do.
No, really.
Maybe you can help me. Your clients went before the HPC, correct?
When specifically? Yes, they did.
In 2018.
No.
When did they
That,
do it?
our position is that the architect did it himself. The applicant wasn't there.
But the architect is under a contractual relationship with your clients. And so it's your client's responsibility to make sure that their consultants or their contractors do what they're supposed to do.
But again, in our opinion, that's
Disagree with
not
that?
really.
Would you disagree with that?
It's not for me to disagree or disagree. Again, to us, that's not necessarily the question, and that's the question that the HPC remained fixated on.
But-
What happened in 18?
Okay, but the HPC set a set of standards or conditions that they wanted, right,
Yes,
in 2018?
yes,
Okay. And the architectural design was done in accordance with those standards. The original architectural design was done within those standards of the HPC.
apparently the ones that were submitted to the HPC by our rogue architect, as we're calling him, did mention the items that they listed in their resolution, yes. But again,
So
our
that
formal-
was incorporated in the drawings and the specifications under the conditions of the HPC in 2000?
Not after the fact, no. The permits that we received are for what was built. Prior to, yes, allegedly, because that's what he submitted, and that's apparently what they touched upon. And certain things they even changed even to those, that submission. After the fact, what was submitted, what the permits we received, are for what was built, which is sitting there now.
Yeah, but who made that decision to change and not follow the HPC guidelines?
The applicant didn't make a decision to change and not follow the HPC's 2018 resolution because, again, they weren't aware that it had happened at all.
But it seems to me the applicant is responsible for what's taken place on that piece of property.
Can I just step in? We're getting into the estoppel issue, and I don't want to do that. But I will say the relevance of the 2018 resolution, okay? I think counsel is correct when he says that the HPC's role wasn't to decide if they violated the 2018 resolution. So they couldn't just go through and say, well, the 2018 said said Chippendale, and now you're not doing Chippendale. So therefore, you can't do anything else. I think they're right about that. That wasn't what the HP is supposed to be doing, okay? So that, but I do think it is relevant that their architect agreed to those items in a 2018 meeting. So, you know, unless he was acting arbitrary and capricious, he thought these things were a good idea and consistent with the guidelines, because their architect agreed with them. Now they're disassociating themselves from the architect, and, you know, that's another thing. But I don't want us to get caught up on whether they are at fault for not building consistently or anything like that, okay? I just don't want us to get back wound up into that again. Let's give that a pass for now. But I do think it's relevant that at some point in 2018, at least their architect thought these things were a good idea.
Yeah, but Rich, but the allegation now is that 2020, new experts came in and said, well, what they built was relevant.
Yes.
So how do you reconcile that?
Well, it's possible that, look, it's possible that in 2018, they had one design, and it was agreed to. And then in 2020, they build something that looks nothing like what the original design was. But it could be even more beautiful and even more consistent with the HPC guidelines. So they could have come in and built the Victorian Hotel, and it would look nothing like what was approved in 2018, but it may meet all the guidelines and be perfectly acceptable. And that's what their argument is, that, okay, we didn't build what was approved in 2018, but it's still within your guidelines and you should have approved it. Okay, and you can't just say, well, it doesn't match 2018, so therefore, it's automatically bad. It could be nothing like 2018, it'd be perfectly good. That's the point he's making to you, is that they could have built replicated Congress Hall in 2020, and it would look like nothing that was approved in 2018, but it would clearly meet your guidelines. So that's their principal argument, as I understand it at this point, okay? But the HPC is saying, well, no, we don't think what you built today is consistent with our guidelines, and we think what we told you in 2018 is consistent with our guidelines, and that's what we would like to see built. Doesn't mean they can't come back with something else, but you read the transcript, and their expert says Chippendale is no good. Mr. Copeland says Chippendale is good. And their expert says, well, it's not Victorian. And Mr. Copeland says, well, we don't just go by Victorian. All right, Mr. Copeland is the chairman of the board, and he has qualifications himself. That's why they're the HPC. So you need to look and see if it was arbitrary and capricious to say what the railings you built, or no railings, is not what we want to see in a contributing building. We want to see things like Chippendale. And you got to decide if it was arbitrary and capricious to reject what they built in favor of what they thought was appropriate in 2018. That's what you're trying to decide. And in my opinion, you do that for each element. I think you need to go down that list, in my opinion, and at least mentally, do that and say they had a basis for rejecting each one of these. And if you conclude that, then that's how you vote.
On that issue, Mr. King, I would just say this. I think that from the HPC standpoint, all of those design elements kind of coalesce into the approval. And I don't know that from the HPC standpoint, piecemealing or doing a line item veto necessarily would make sense from their perspective, because
I think that's the one thing we might actually agree on there, is that the record is clear.
Right.
There's no need to necessarily piecemeal it out.
I can
No,
see.
I don't think you have to piecemeal it out in your votes. I just think mentally, I do think that if the HPC said you need to install a cupola on top of that, and the guidelines don't call for a cupola, then I think that would be arbitrary and capricious to require a cupola where one isn't in the guidelines. So, each one of these are touched in the guidelines, and I get it, it's a whole project, that's fine. But I think, in fairness, I think you need to think about each one of them. You can't just blow past them, so.
Can I say the reason for that, too? And I think it's because, especially in this context, there was such a change to this building, and mostly for the positive, right? But I think Mr. Primavera's testimony is over 90% of this building is new, and it was contributing. So these little design elements, I think, is really what keeps it within the historic preservation guidelines altogether.
Well, they seem to agree to do it as a whole, that's fine. I
Yeah,
just,
I agree, because if they if they rebuilt the building like Congress Hall, we wouldn't be here, right? I mean, it would be, I'm sure the HPC would have said, okay, it's fine, it looks great, but they didn't, and so that's why we're here. Was that decision arbitrary and capricious? I think.
That's the question.
When you get conceptual approval from the HPC, when do they go back for the final approval? I mean,
well-
does anybody from HPC go out and look at it before they come? Well, the final approval they don't do that until it's completely done? I'm a little confused by that.
no, the final approval is supposed to be issued before there's a building permit. But they did issue final approval to an architect that they say isn't their architect.
We didn't say he wasn't our architect. We said he acted independently of the applicant.
And they didn't know that he went and got final approval. So without knowing
Or
whether or
didn't
not,
get final approval?
well, he did. But then they
Well, that's an open question as well, but that's a completely separate issue in terms of absence of counsel and all
Well,
that stuff.
don't worry about anything.
Yeah.
No, don't worry. I understand it's a curiosity, and it's curious to me too, but we analyze what the record is. You need to look at what was built, and they say that what was built meets the guidelines and should have been approved. The HPC disagreed with them and said, we like the stuff in the 2018 thing, and we're gonna stick with that. And you need to decide if that was arbitrary or capricious. Does anyone disagree with that summary? That's what we're doing, right?
No, I think it's pretty accurate.
All right, then maybe we could do it.
We don't open this to the public.
It's an appeal application. I don't know that this is an
It would not,
application for
because
development to open
you'd
to
be
the public.
supplementing
Exactly.
the record.
Right,
Exactly.
so we don't do that. Okay. Craig, do you have anything you want to say?
No, I think you're relying on the record.
Okay. All right. Okay. We want to make
So what are we being asked to vote on? Whether or not the
who's going
decision
to tell us?
of the HPC was arbitrary and capricious?
Yes. So it's a motion to affirm the HPC's decision and find that it was not arbitrary and capricious to issue the resolution that they issued. So if you vote yes, you are affirming their decision. If you vote no, you are reversing their decision.
Very good.
Okay?
May I just ask if you're going to open to the public?
We are not.
Okay, thank you.
So just so I'm clear,
Yes, sir.
yes, you're affirming, no, you're reversing.
right? Yes, we are affirming the HPC, no, we are reversing the HPC. If they vote no, then I may have to do, talk about some other things, but
Sure.
let's see how it goes.
Everybody okay with that?
Yes means you agree with the HPC's position. That's
There
the
you go.
motion.
Okay. I'll make the motion. You want me to make the motion?
Yes, go
Okay,
right
well, I'll make the motion as articulated by our counsel.
Second.
Okay, I think Jenny beat you, Norm. Motion by Mr. Murray, seconded by Ms. Hessel. Mr. Walsh,
Yes.
Mrs. Notch,
Yes.
Mr. Ledwin,
Yes.
Ms. Hessel,
No.
no. Mrs. Werner,
Yes.
Mr. Murray,
Yes, and let me make one comment. The reason I'm voting yes is because after reading the transcript and reading everything that we had to read here, it was my impression and opinion that after hearing the applicant and expert testimony, the HPC determined that the building is in the historic district and is a contributing building. And to me, that was not arbitrary and capricious. It was a precise determination made by the experts in the HPC. So I'm voting yes.
Mrs. Hutchinson,
Yes.
thank you.
Okay, I have 6-1. Is there anything further we need to do?
Not that I'm aware of.
Okay. Thank you, Counselor, for your good work.
Thank
Thanks,
you.
argument.
Thank you very much. We appreciate the board's time.
Do we have a motion to adjourn?
So moved.
All in favor?
Aye.
Thank you. Have a good night, everyone.